All right, welcome to this explainer. Today we're diving deep into how some brand new protocol-level tools are finally, and I mean finally, solving the massive issue of open source extraction. And when I say protocol level, I just mean rules that are baked right into the foundation of the internet itself, not slapped on as an afterthought. You know, for decades, our digital economy has been stuck in this wild tension. Creators build all this incredible value, but the system is literally designed to funnel that value away from them. Well, today we're looking at some architectural breakthroughs that are completely changing the game.
Let's kick things off with what you might call the ultimate inventor's mandate. It's a concept that totally flips traditional software economics on its head. Author opt-in for revenue, consumer zero cost. I mean, it's a beautifully simple but radically disruptive idea, right? Imagine if invention was this deeply collaborative social ecosystem where the underlying code automatically rewarded the creators instead of just feeding centralized mega platforms.
So, are we actually ready for a system that pays the creators? That is the billion-dollar question. We're addressing the incredibly real pain of developers who watch their work get endlessly extracted by massive commercial engines. Think about it. We're building these colossal AI systems, but the everyday people supplying the vital, aggregated human labor, what the law calls the sweat of the brow, yeah, they're usually left completely uncompensated.
We've got a ton of ground to cover today. We'll be mapping out the corporate extraction problem, looking at the broken patent system, introducing the EGPL defensive shield, breaking down ERC 6969 as a monetization engine, and finally, exploring the permissionless patent.
All right, starting with Section 1, the corporate extraction problem. Let's look at the actual dilemma that everyday innovators are facing right now.
Basically, creators today are caught in a trap. You essentially have two choices. On one hand, you've got standard open source. It relies on traditional copyright disclaimers, which fixes the cost issue for consumers. They get it for free, but the authors starve while massive corporations gobble up their code for $0. On the other hand, you have traditional patents. Sure, authors might get paid, but it creates this deeply exclusionary, expensive monopoly. It locks your work behind a massive legal wall that only well-funded giants can actually afford to climb. It's a completely broken binary framework. Moving to Section 2, the broken patent system. To truly understand why we need a new way forward, we kind of have to look at how deeply flawed the old intellectual property web actually is.
$12.5 billion. That is a staggering number. It's what Google paid for Motorola Mobility back in 2011. And here's the kicker, it wasn't really to get their phone manufacturing plants. Nope, it was primarily to acquire 17,000 patents to build a massive defensive shield against their competitors. It perfectly highlights the absurdity of our current setup. Today, patents are often way less about actually making a brilliant new product and a whole lot more about just stopping anyone else from making one. It's an ecosystem where the biggest legal budget usually wins out over the best invention.
It's honestly a system where brilliant, rogue geniuses can have their celebrated, industry-proven work completely dismantled. Take Checksums, for example. These guys literally won an Emmy for their digital wireless microphone tech. An Emmy! But massive competitors basically just infringed on their work and then spammed the Patent Trial and Appeal Board, the PTAB, with overlapping petitions. The PTAB is increasingly used as a bureaucratic weapon to just drown smaller creators in legal paperwork until they run out of cash. For Checksums, their patents were invalidated a full 14 years after they were issued. 14 years!
Which brings us to Section 3, EGPL, the defensive shield.
So how do we actually fight back against that? Well, the source material introduces something called the EGPL. Think of it as a modern technical statute of Anne, which is a nod to the world's very first copyright law. But instead of relying on slow courts and expensive lawyers, the EGPL anchors the defense right into the technical architecture. It acts as a copyleft poison pill. Basically, if a closed system ingests this open source code without permission, it triggers a hard-coded legal requirement for that closed system to become open source itself. It turns the weapon of IP law into a proactive, defensive shield.
And the mechanics of this are brilliant. It sets strict network boundaries and mandates source code disclosure the second there's network interaction. So if a massive AI corporation tries to scrape and mine your code for their closed-source models, they are legally forced to open-source their proprietary tech in return. The very moment their servers connect to your code, bam, the requirement kicks in. It perfectly balances protecting the economic and moral rights of a project. It's a smart legal document engineered for true creator sovereignty.
Now, on to Section 4, ERC 6969, the monetization engine.
Because, defense is really only half the battle. Creators actually need to get paid for their sweat of the brow. So let's look at how this works in practice with ERC 6969, which introduces Contract Secured Revenue, or CSR. Normally, when transactions fire off on a blockchain, the fees go to sequencers. They're basically the toll booths of the network, and they keep all the money. But ERC 6969 seamlessly routes those tool fees away from the centralized sequencers and sends them directly back to the author. It anchors this revenue right into a CSR NFT. You can think of a CSR as a digital deed that mathematically proves exactly who wrote the code and who deserves the royalties.
It actually mirrors the music industry's performing rights organizations, which I think is a super helpful way to wrap your head around it. When you listen to the radio, the song is free for you, but behind the scenes, commercial radio stations are paying into royalty pools to compensate the songwriters. By baking this directly into the protocol, the open source code stays completely free for a solo hobbyist to use and tinker with. But if a massive commercial factory takes that code and plugs it into a high-volume revenue engine, triggering it thousands of times a minute, automated micro-royalties instantly kick in.
And that leads us to our final section, Section 5, the Permissionless Patent. Because when we synthesize that EGPL shield with the ERC 6969 monetization engine, we unlock an entirely new paradigm. Think about the stark contrast between these two models. We are officially trading a heavy, expensive reliance on state-granted legal authority for undeniable cryptographic evidence. Traditional patents rely on a judge to enforce your rights. And as we saw with Zaxcom, that can mean 14 years of brutal litigation and millions of dollars. The permissionless patent, it relies on protocol-enforced evidence. The access stays open, but the system uses pure math and cryptography to automatically execute your royalties. It literally cuts the legal middleman entirely out of the loop.
The absolute core of this whole thing is a concept called technical inalienability, which is just a fancy way of saying that the right to be compensated cannot be separated from the code itself. It is hard-coded into the architecture. We're engineering a systemic digital sandbox that protects the creator's value at the silicon level. And by silicon level, I mean it happens automatically at the computer processing layer. No lawyers, no agonizing court battles, just a space where abundance compounds naturally because the author is finally sovereign. So I want to leave you with this as we wrap up. Think about how these Web3 primitives are fundamentally rewriting the future of the internet's creative economy. The EGPL and ERC 6969 prove that we can build a system where abundance compounds naturally, simply because the protocol itself has the creator's back. So what do you think? Are you ready to shift from a world of permissioned license use to a world of witnessed automated value? If code really is the new law, isn't it about time we wrote better laws into our code? Thanks so much for joining me on this explainer.